Good afternoon, everyone, and welcome to this afternoon's webinar. My name's Jackie, and today I'm going to be your host. We're going to be looking at onboarding success, so looking at compliance and supporting your employee rights from day one. So as I mentioned, my name's Jackie. I'm a learning facilitator at Sage, and I'll be your host for today. First of all, we'll just do some housekeeping. So just in case you haven't joined any of our sessions before, your microphone has been placed on mute, and that just means that you can't speak to us today, but you are more than welcome to submit your questions across to us today using the icon that looks like a speech bubble with the question mark in the middle to send your questions across to us. And we'll try and pick out as many different ones as possible and answer as many as we can. If we can't cover those during the session, then we will follow up after today's session for you. There is a handout for today, and you can use the icon that looks like a document with the folder corner, and that will allow you to take a copy of today's slides. And after today's session, there will be a follow-up email that will have some of the useful links for you. It will also have a link to recordings of our previous sessions, some of which we'll refer to today as well. Okay, so as I mentioned, I'm a learning facilitator here at Sage UK, and I normally cover the account side of things, so you might not be as familiar with my face. However, we do have our guest speakers today, both Kelly and Jack, who are joining us from Advisor Plus. So we've got Advisor Plus HR Technical Consultant Kelly Armitage, and also Senior HR Advisor Jack Jones, and they're going to share their extensive employment law expertise and also share their views on common issues that you may experience as well. So Kelly, would you like to start with your introductions?
Yeah, thank you very much. Hi, my name is Kelly. I've worked in HR for nearly 20 years, working mainly for large corporate organisations, including chemical industry, security, criminal justice and the transport sectors. I've completed my level 3 and 7 in CIPD qualification, and I've worked for Advisor Plus for 11 years. My role as a HR technical consultant means I get to work closely with the clients and the advisory team, as well as having the opportunity to work on a variety of HR consultancy projects. I've got experience working on complex HR topics such as grievance, disciplinary, managing underperformance, and many others. Jack, would you like to introduce yourself?
Thank you. So, hi everyone. Yes, my name is Jack. I work in HR. I've been working in HR for 6 years within industries including the UK holiday park resorts, an airline and warehousing. I am level 3 and level 5 CIPD qualified, and my role as a senior HR advisor means I work on the advice line supporting clients with their ER needs, covering topics such as disciplinary, grievance, flexible working, and some that we are going to discuss in the session today.
Excellent, thank you very much there. So what we're going to be covering today is we're going to go through these areas. So we're going to first of all look at understanding day one employee rights and employer obligations. We're going to also take a look at crafting clear contracts, policies and procedures, navigating legal compliance, including wage laws, working conditions and discrimination protections, and addressing common pitfalls and best practices for a seamless onboarding experience. Okay, so we're going to get a start straight away. So over to you, Jack.
Thank you. So I'd actually like to start by going back a stage further to before day one, as there are some rights that apply even before employment begins. Individuals have a legal right not to be discriminated against in recruitment, so consider for a minute your advertisements, your interview and selection processes. Job adverts need to be inclusive and formatted in an accessible way. An application process could offer options such as larger font or to be made available in Braille. Also consider the wealth of talented individuals with neurodivergences, such as dyslexia, who may benefit from a straightforward font, and you should avoid jargon or overly corporative language. Ensure language is gender neutral by using they or we rather than he or she, and you should also avoid phrases that may put off younger or older applicants. So for example, must have at least 10 years experience. This can put off younger applicants, and something like they must be tech savvy, which could put off older applicants who could actually be taught the relevant tech skills in the post. When inviting a candidate to an interview, ask them to let you know if there's any reasonable adjustments that they need in order to make sure that you afford them with an equal opportunity. When when selecting your successful candidate, also take time to focus on the facts such as their responses, their skills and experience. A decision must be capability based, and we all have unconscious bias, which can impact our selection even without us realizing it. So take time to check yourself, your reasons, and why you're favouring a particular candidate. Ensure that any notes taken during the recruitment process are factual, fair, and professional, as the candidate does have the right to see a copy of these should they submit a subject access request. A candidate can put in a claim for discrimination if steps are not taken and considered from the earliest point, even before an employment has begun. Ensure that hiring decisions are fair and based on skills and experience for that role.
Thank you. So yes, it's a good point. We need to have that awareness of rights, in particular, not to be discriminated against from that pre-employment relationship. So once the candidate has been selected, what next?
So from day one of employment, there are several rights and protections for employees which have been passed through Parliament over the years and have become law. Some don't kick in straight away, however, plenty do and apply to all sectors and professions. So I'll break some of these up into chunks, starting with pay. These include a right to be paid at least the national minimum wage, which is dependent currently on an employee's age, and my colleague Kelly will go into this further in a bit later on. There's a right to receive a pay slip showing gross and net pay and any deductions, a right not to have any unauthorised deductions from pay, and a right to be paid for any outstanding holiday they've accrued and not taken before they leave, when they leave. There's also a right to statutory sick pay. You can find out more about pay rates on the government website, or Sage subscribers can find this out on the Sage site using the portal. So I'm going to move on to hours and breaks next. Employees have the right to reasonable working hours and breaks. You must give a minimum of an unpaid break of 20 minutes after a colleague has worked 6 hours. You must also ensure there is a daily rest break of 11 hours between shifts in every 24 hours. There's also a right to a weekly rest break of 1 day off in every 14 calendar days. Some organisations choose to offer more breaks. However, these are the legal minimums you must provide. Employees have the right to request flexible working from day one now too. Employees should have a procedure for handling such requests. And you may have also heard of the Working Time Directive, which is worth familiarising yourself with in relation to the maximum working hours. So on this, employers mustn't work more than 48 hours a week on average, and this is averaged out over a 7-week period. If they're 18 or over, they can choose to opt out if they do not want to work more hours. If they want to work more hours, you can check the Working Time Directive for more information on this. There are some variations, though, to be aware of. So workers who are 16 or 17 cannot work between midnight and 4 a.m. And as well, for under 18s, it differs for night workers who can't work more than 8 hours in a 24-hour period. So just continuing off then from time off and leave, employees are legally entitled to several kinds of leave, and I will go into these now. So holiday, the full-time equivalent of 28 paid days annual leave a year, although in the first year, strictly, they can only take what they've accrued to date. There is an entitlement to 52 weeks leave for maternity leave or adoption leave. Employees also have the right to have paid time off to attend antenatal appointments and their partner to have unpaid leave to attend 2 appointments with them. And non-employees are also entitled to have unpaid time off to deal with unexpected emergencies involving dependents or close family members. Employees have the right to an employment contract from day one, which, again, my colleague Kelly will discuss this shortly with you. When the New Employment Rights Bill comes into effect from 2026, there will be some further changes then to plan for. We discussed, for instance, in our last webinar, the right to claim unfair dismissal from day one and the impact that this may have on how we manage probation going forward.
Yeah, and that bill is certainly one that we'll be watching here at Sage as well. So before we move on to think about contracts and policies and what should be included in these, is there anything else in terms of obligations on employers to have in place from day one?
Yes, Jackie. So there are other obligations on employers from day one, such as health and safety and risk assessments. There is a duty to protect employees' health and safety, carrying out risk assessments, and also taking reasonable steps to ensure the health and safety of others at work. Requirements differ depending on what type of workplace and industry you run, so I'd recommend finding more information about what applies to your workplace, and this legislation is the Health and Safety at Work Act 1974. Linking back to discrimination and equality for a second, so all employees have the right not to be harassed, victimised, or discriminated against in the workplace. Discrimination can be unacceptable behaviour related to what we call protected characteristics, and these are age, gender, disability, sexual orientation, race, religion or belief, marital or civil partnership status, gender reassignment, and pregnancy or maternity. Employees who are part-time or on a fixed time contract have the right not to be treated less favourably. Employers are obliged to make reasonable adjustments for employees who have a disability. So this is something to bear in mind when you have individuals with underlying health conditions that can impact them in work. And also, those that are off sick, you may want to consider reasonable adjustments to enable them to return to work and stay in work. Employees have the right to belong to a trade union and not to suffer any detriment linking them to union membership or union activity, including strike action. And also protection against suffering a detriment or dismissal due to whistleblowing. There is certainly a lot to remember there, so it can be really useful to have a robust contract and staff handbook to set out these rules and standards.
Thank you for that, Jack. So this is all really useful, and given that you've highlighted the importance of contracts, it would be a good point to move on to contract and policy. So Kelly, can we have your thoughts on this point?
Yeah, absolutely. So as you say, it's important to ensure that you do have clear contracts and policies and procedures in place. So employers now have to provide a written statement of employment particulars either on or before the employee or the worker starts. This can be included as part of the employee's contract of employment. A written contract allows you to include additional terms and conditions of employment that goes over and above those that are required by law to be included within a written statement. So the contract is the first formal agreement between you and your new employee. It's therefore important that any agreements and expectations are clearly stipulated within the document just to avoid any future misunderstandings. The contract should include the employee's salary, start date, job title, hours of work, and their terms of conditions, including any sickness pay entitlement. And that should be issued as soon as possible, but no later than 2 months from the first date of employment. So whilst it's not possible to include an exhaustive list, certain behavioural expectations can be documented within the contract, such as a confidentiality clause and references to internal policies and procedures, such as disciplinary, performance and conduct rules. So if your business does not have separate policies, you may wish to include a copy of the staff handbook as part of the supplementary information to the contract. You can also review the Sage HR advice and guidance pages for more information on what these policies and procedures should include. It's also worth noting that any changes to the contract must be put in writing within 1 month of the change.
So again, a lot to consider there, and it is really clear there how important it is to have contracts and policies in place. So with that in mind, Kelly, can you please help us explore navigating legal compliance and what else that includes?
Yeah, absolutely. So as you say, we're looking at navigating legal compliance, including wage laws, working conditions and discrimination protections. So specifically, we're looking at pension auto-enrolment, national minimum wage, holiday entitlement, carers leave, and finally protection from sexual harassment. So I'll start with pension auto-enrolment. As employers, you're legally required to enrol eligible job holders, including new starters, automatically into a pension scheme that meets certain minimum statutory requirements. And that's all employers. It's not affected by the number of people employed. You're legally required to make a minimum employer pension contribution for eligible job holders, and that's known as auto-enrolment. This has now been fully phased in. For additional information, you can view the pension auto-enrolment topic within the Knowledge portal. Moving on to the national minimum wage. So the national minimum wage is payable to most workers who ordinarily work under contract in the UK and have ceased to be of compulsory school age. You should keep a record that shows you're meeting your legal obligations under the National Minimum Wage Act 1998. So these records should be kept in a form that allows details of a worker's pay in a pay reference period to be produced in a single document. The worker is entitled to inspect the reports if they have reasonable ground for believing that they've not been paid the national minimum wage. So the national minimum wage is gross pay. It includes bonus payments, and the cost of providing accommodation can be included up to £9.99 per day or £69.93 per week. Some parts of pay don't count towards national minimum wage, and these include repayment of expenses, tips and gratuities, extra pay for working bank holidays or overtime, loans from the employer, a pay advance, redundancy pay, and benefits in kind such as childcare vouchers, company car and fuel, and work mobile phones. So the national minimum wage rates are reviewed every year and are usually updated in April. The current national minimum wage rates are, for those aged 21 and over, £11.44 per hour, 18 to 20, £8.60 per hour, under 18, £6.40 per hour, and apprentice, £6.40 per hour. However, any apprentices aged 19 or over that have completed their first year of their apprenticeship would be entitled to the 18 to 20 hourly rate, which is £8.60 per hour. Like I say, these rates are the current national minimum wage rates until April of this year, when they are scheduled to rise again. So keep an eye out for what that raise looks like. Holiday entitlement. So where employees do not work a fixed number of hours or their hours vary week to week, the average pay should be calculated over the previous 52 weeks. This should include contractual commissions, overtime, including voluntary, compulsory and non-guaranteed, which have been regularly paid to a worker in the 52 weeks preceding the calculation date. Also bonuses and travel allowance as well. If the worker has been employed for less than 52 completed weeks, however, the relevant calculation period is the completed weeks for which they've been employed. So looking at carers leave. So the Carers Leave Act 2023 provides all eligible employees to take unpaid leave to give or arrange care for a dependent with a long-term care need, i.e. a physical or mental illness or injury, meaning they're expected to need to care for more than 3 months, or a disability or requires care because of their old age. So employees are entitled to take up to 1 week unpaid leave in either half or full days or a whole week in every 12 months. The right to take carers leave applies from the first day of work. And then finally, I'm just going to cover sexual harassment. So the law on preventing sexual harassment in the workplace changed on the 26th of October 2024. By law, all employers need to take steps to prevent sexual harassment, and so it's vital that all employers take a proactive approach to educate all employees to ensure an inclusive, respectful and safe workplace. Steps to take include creating a sexual harassment policy, training employees on sexual harassment and the policy for your business, stressing zero tolerance approach, reviewing employment practices and dealing with complaints. Again, further guidance and support can be found on the Sexual Harassment Toolkit on the Knowledge Portal.
Thank you, Kelly. And it's a really good opportunity as well, just to remind you that we did do a session on sexual harassment back in October or September last year. And a recording of that is available to view now. So if you did miss that, please do check out that recording when you get a chance. So now we'll move on to the final section, which is addressing the common pitfalls and best practices for seamless onboarding experience. So Jack, what are your thoughts on this?
So, onboarding is so important given the amount of time, planning, resource and cost that goes into the recruitment process. Without a smooth and successful onboarding experience for an employee, this can often impact how they settle into their role and the business culture. There can often be common pitfalls which may have a negative impact during an induction, and these can, for example, be bombarding the employee with too much information, leaving the employee to take breaks alone or spend extended periods of time working alone without contact, or throwing an employee straight into the job without any support or induction plan. Now, there are a couple of things for you to consider that may help the employee to settle into a role within the first few weeks or months of their employment. And I would recommend carefully preparing a plan for the induction from the start to the end of the period. Don't overload the employee with too much information on their first day. Take the opportunity to introduce the employee to members of their team so that they can fully understand the structure of the business. This also helps them to understand the roles and responsibilities of others within the team. Take time to review and discuss what has been covered during each stage of the induction period, so then you can gather some feedback. Consider what training the employee needs and plan time for them to buddy up, attend training workshops, or even complete e-learning. By not setting the employee up for success from the start of the employment can create a poor impression of the business and could undo the work which attracted and secured that new recruit. A good induction can help set the business expectation and give the employee a good feel for the brand, workplace culture, and values within that business. An induction can last for a few days, a few weeks, or some months, depending on the size of the business. Although I would highly recommend, and it is essential, that health and safety is outlined on day one. You may want to consider the following steps when planning an induction. So you may want to provide a welcome pack prior to the employee starting their new position. This could be sent via post or emailed electronically. And the pack can include a written statement of terms and conditions of employment, information about the company, and include the staff handbook. As detailed above, create an induction plan with timeframes for when each task should be completed. Create a checklist to help the employee take some ownership of their own induction. Tailor the induction to the employee's previous experience. For example, an employee who's just finished university may need longer than an employee who has been previously employed in a similar role. And that you need to be mindful of working patterns, as the employee's shift may not align and may need to be amended slightly during the induction period in order to get the best out of their time, so that they can see all areas of the operation if they obviously work different hours to the set ones that the employee might have been employed into. You should allocate a buddy or a mentor as someone that the employee can check in with, and they can go to them with any questions if they need. You should ensure that the employee has all the correct equipment and access codes where needed, and it is also essential that they have security passes, photo IDs, locker space, and contact numbers from day one. I would also recommend that the induction plan outlines what areas need to be covered as part of the induction and by what date, and the employee should have completed each section. This can be reviewed and amended as agreed between the employer and the employee as you go. Another point to consider is if you are planning an induction for one employee or for a group of employees, as it can often be beneficial and cost effective to coordinate an induction for more than one employee at the same time so that they can be trained together. And also it helps them to start building relationships and helps them settle into their new role. So I'm going to go with setting the expectation next. It is always helpful to explain the business rules such as working practices, policies, expected behaviour, unacceptable behaviour, and procedures if rules are broken. I've had several HR cases where the manager wants to end probation in the first few weeks. This can sometimes be a result of a poor induction process or a breakdown in communication, which leads to an employee not achieving their objectives and performing at the right level early on in their employment. I would always encourage an open and honest conversation in the early stages of induction, which the employee, as this, can iron out any concerns. Having an open and honest conversation can also give the opportunity to raise any issues or highlight what they may require, for example, reasonable adjustments to support them in achieving their objectives. As part of the induction process, probation should be explained to the employee on what the process includes. So set out when the probation review meetings will take place and what is required during the probation period. For more details around probation, this can be found on the government website, or for Sage users, all the information can be found on the website or the Knowledge portal. A smooth and well thought out induction process should encourage a settled and established employee, therefore increasing retention and creating an experienced workforce in the long term.
Excellent, thank you for that, Jack. So there's been a lot to take in there. So what we'll do next is we'll move on to questions. We've got a little bit of time to field your questions. We've had quite a few come through. We'll try and work through as many as possible. So the first one there that I'm going to pop over is, could there be a financial cost to the business for not implementing reasonable adjustments from day one? So I'll pop that one to you, Jack.
Thank you, Jackie. So I'll start with the fact that there are some historical employment tribunal awards that have been given out. So a couple examples of these are £25,000 was issued to an employee, which included injury to feelings for failure to make reasonable adjustments. And the biggest example I can give is in 2021, an employee received £2.5 million for disability discrimination, which included failure to make reasonable adjustments. So it's definitely one for you to consider. And if you've got any queries or questions, obviously you can refer to the government website, ACAS, or the advice line.
Excellent, thank you. So the second one we've got there is, does an employee need to evidence or to prove that they're a carer? And if so, what documentation would they need to provide? I'll pop that one to you, Kelly.
Yeah, so employees don't actually legally have to provide evidence to prove that they are a carer, and they're also not required to provide evidence of their dependents' care needs. There are, however, set definitions of a carer and their relationship between the employee and the dependent to allow them to take that leave. So the definition for a dependent is either a spouse, partner or civil partner, parent or child, or anyone else who relies on the employee to provide or arrange care, or a member of their household. That, however, doesn't include people like tenants, lodgers, boarders, and household employees. So whilst the employee does not need to provide any evidence and in fact put their request in writing, it is recommended that you do keep a record of time off for carers leave that the employee has taken, just to ensure that they don't take more than the 1 week of leave within every 12-month period.
Excellent, thank you. And the next one there is, should the induction plan be in place from day one?
I will take that one, Jackie. So just following on from obviously myself talking about induction plans earlier, I would advise that drafting a plan ahead of a new starter coming in on day one is ideal. And the induction plan, yes, it should be in place from day one. And further information about that can be found on the Knowledge Portal, or if you're a Sage Uni user, you can see it on the portal, or you can refer to ACAS. But definitely drafting that induction plan ready from day one when they come in is definitely beneficial, and I would strongly recommend.
Excellent. Okay, we'll move on. So can a business be held liable for any sexual harassment between two employees outside of work? So this is a really interesting one, this one.
Yeah, I'll take that one. Great question. So the short answer is yes. Whilst the employees themselves have ultimate responsibility for their own actions, employers can also be held responsible for the actions of their employees if they've not prevented sexual harassment from happening in the workplace in the first place. And that's known as vicarious liability. So this is where one employee acts in a discriminatory way towards another employee within the workplace. So work events are considered an extension of the workplace. And so any work events such as Christmas parties, any other work type parties, conferences, training events, or via social media as well, that's linked to the company may make the business liable for any sexual harassment claims. So employers have a responsibility or a duty of care for the well-being of their employees. And if that doesn't happen, then that would be considered a breach of the employee's contract of employment if the employee feels that they've got no other option but to quit their job. And that could in turn result in a claim for constructive dismissal. This is why it's so important that sexual harassment is taken seriously and investigated in every case. So a tribunal, should it go to a tribunal, would consider if the business has taken every possible step to avoid sexual harassment from happening in the workplace, including having a sexual harassment policy, training employees on that definition of sexual harassment and training on the policy itself, but also investigating any complaints that have been raised. Other steps that employers can also take is to carry out a risk assessment, just so you're at the front of that, just to review factors that might increase the risk of sexual harassment. So some risk factors might include staff working alone, for example, or working at night, staff socialising outside of work, and reviewing if there's a lack of diversity in the workplace as well.
Excellent. Thank you very much. Lots of information on there as well. I'm going to just take the next one because it links in very closely to this one. And it's not often I get to answer a question on these ones. So I just want to show you where you can find out some more information about sexual harassment. So one of the questions was, can you show us where to see that recording? So if you go to sage.co.uk/webinars, it will take you to the page that you can see on the screen now. We do have our own little tile for HR advice. And if you click on here, you will be greeted with this window here. It will show you all of our upcoming webinars, but also if you do look a little bit further back, you will see our recording from October. So that's a really good one to follow up on. And we did also touch on it in our festive one as well, which does talk about outside the work environment as well. So they're probably two to maybe take a look at on the sexual harassment side of things. I'll pop back to the questions there though. Let's keep going there. So Jack, I'm going to pop one across to yourself there. Bear with me. Recruitment. So if you're specifically looking for staff with a certain number of years experience, so you mentioned earlier about not excluding sort of younger applicants, how best would it be to explain that in the job advert?
So I think you need to consider the language around how you're setting that out in an advertisement. So maybe avoiding the word essential and you might want to put the word desired. I feel like the word essential is what might throw some people off. They might read that, go to the word essential, see that you need 2 years experience minimum, and then they'll be put off by applying potentially. So the word desired, I think, is a bit more warm and will make people think, okay, I haven't quite got the same amount of experience that they're asking for in years, but I have something close to, so I might still apply for that. I guess also consider, is there anything else aside from years experience could you take into account for a potential candidate? So potentially qualifications, would they suffice? So I think it's definitely around assessing the wording in that advertisement and staying away from the words essential and maybe look to use the words desired.
Okay, excellent. And how long should interview notes be retained for? So when you mentioned earlier, if a candidate can submit a subject access request, so how long do you have to retain that information for?
So in terms of employment, when a colleague is in and they've got their personal data, this should be outlined in a policy. It may be titled Employees Privacy Policy. So retention dates and how long they will keep documents should be highlighted in that. In terms of recruitment, so I've just got a couple of general examples to give. So I'm aware of a business that's kept them for 9 months as an example. Some will keep them for 12 months. So you need to consider what's reasonable, because for example, if you're going to retain documents on somebody, which includes their name, it can include their address, it can include their email and phone number, what's a reasonable length of time to be able to obtain such information? Because if you're going to keep them in a bit of a pool and reach out to them if the job role becomes available again in the future, are you going to be ringing somebody 12 months down the line and they're going to say, how do you still have my details? So you also, as a bit of advice, is you should ask if somebody wants to opt out. So there are automatic emails that an employer might send for a successful candidate or an unsuccessful candidate. And I would always advise to caveat the email with, if you would like for us to remove your data, please respond to this email, or for example, click this link, and it might be like an opt-out, and then therefore their data would be removed, and highlighting that as well. Otherwise, your data will be retained for example, 9 months. I think if anybody's got any queries around the length of time that data can be retained, they can ask, for example, if they've got information security advisors available to discuss, or give the advice on a call, and an advisor might be able to discuss and pinpoint directly where you might be able to find this information.
Excellent, thank you. Okay, I think we'll pop on to Kelly there. Do employees have to sign a statement to indicate that they've read and agree with the company handbook?
I would say that it's certainly best practice to do so. Certainly, if you're going to rely on that as part of evidence for, let's say, a conduct investigation. So, an example I gave earlier on, where you may want to put a confidentiality clause, for example, and there's been a breach of confidentiality, then you have that evidence straight away. There's no dispute whether the employee later on they can say, actually, I signed it, but I didn't read it. But they're signing to say they've read it and they've agreed on it. So you'd be in a stronger position to use that at any investigation as evidence. So I would always recommend that there's something in your staff handbook that you ask them to sign that. Obviously, depending on the length of your staff handbook, you may need to give new employees time to read over that. But certainly, yeah, it's best practice to have something towards the bottom for them to sign.
Yeah, completely makes sense, doesn't it? You've got that to cover you going forward. We'll try and squeeze a couple more in just before we move on there. Like I said, we haven't managed to answer your question. Apologies. We will try and reach out to you after today's session. But there's lots and lots of questions on these topics each time we run these sessions. So I'll just do, I think, two more. So how would you suggest to set up a new employee for remote working? Any special tips on creating a supportive environment for them? So I think that's quite topical at the moment, isn't it?
Sure. And I'll take that one, Jackie, if you don't mind. So I think with remote working, I think you should assess location. So in terms of that day one, can you get that colleague to meet within an office environment, one of the sites for the business, so that you can have a bit of a face-to-face interaction on day one, depending on obviously, like say, how far they are to travel, depending on their location. If not, then most companies for remote workers will issue out equipment via delivery, and then once they're set up on their first day, they might suggest doing a Teams call first thing to catch up, to get them familiar with their equipment, what it can be found where, what can be accessed how, etc., etc. So you might want to set up that call, first thing in the morning if you're not able to meet face to face on day one, to really go through how they should be accessing things, who they should contact for what. For example, like I mentioned earlier with the induction plan, you might want to share numbers, you'll have to discuss about any security codes, passwords, etc., etc. So this should all be done from that day one. I think to help settle them in, you might want to do some arrangements of other meeting calls with other members of the team, so they get introduce themselves to the team, can get to know what their job role is, what their part in the team is. And then that can really help settle them in then and feel encouraged to then maybe chat to other people if they've potentially got any questions or they've got any queries. Then they feel more settled in to sort of reach out to these people if they've had a bit of a warm welcome over a video on call. So that's just a couple of suggestions on how I would advise to help settle in a remote worker from their day one.
Fab, and I think we'll go for one more. So can a case be brought against you for discrimination on the grounds of maybe disability or a medical issue if that employee has not disclosed that information at the beginning on a medical questionnaire? So Kelly, I'll pop that one to you if that's okay.
Yeah, absolutely. So we can't obviously force employees to declare any disabilities and medical conditions within, those medical questionnaires. So this question is probably a dependent on the tribunal. So what a tribunal would look at is, one, whether the business was aware, so if an employee did or didn't declare it, but also tribunals will also look at whether it would be obvious to an employer that they should have known. So if you have concerns or you have an inclination that an employee might have a medical condition that you do need to be aware of, absolutely, have that delicate discussion within a welfare meeting, for example, just to say, we've noticed some concerns. Is there anything you need to let us know so we can potentially put in any reasonable adjustments? And if they still say no, then again, unfortunately, it will be a tribunal to determine that. But just because an employee has not declared it at the initial using that questionnaire questionnaire doesn't mean that a claim cannot be brought against an employer. They will certainly look at other factors in terms of whether it would be reasonable for the employer to know about it without the employee declaring that.
Excellent. Thank you so much for that. We've covered as many as we can in the time. We've just got a few minutes just to wrap up the session there now. Okay, so as I mentioned at the beginning, you can download a copy of today's slides with all of the information we've covered today. So if you want to download that, you can use the icon. It looks like a document with the folder corner, and that will give you a copy of today's slides. If you need any more help with anything we've covered, then please do feel free to check out any of the topics on our HR advice portal, and there are links again in that handout there. Alternatively, if you're on professional or premium, then you can call the advice line as well, where one of our consultants will happily provide you with guidance on any of the topics that we've covered today. Okay, so moving on, I think I've just gone too far there. I'll just go back one. There we go. So just to let you know that HR Advice is here to help you navigate and simplify these processes that we're talking about today. And alongside Sage HR, you can automate and simplify your HR tasks, such as calculating things like your holiday entitlement, arranging shift scheduling based on people's contracted hours. And you can automatically log hours worked as well. So with that, I'm just going to pop on a quick poll, which you will see on your screen in just a moment, just to see if you want more information about our Sage HR product. Okay, so this is just a quick question. It's a yes or no. I'm just going to pop that across to you now. So if you are interested in finding out more information about our HR product, then please do pop a yes in there, and one of our team will be in touch with you to discuss your needs. If not, please do let us know, and we will remove you from that list. That's no problem at all. Okay, I do just like to give it a few moments just to make sure all of those votes come across. And there is a slight delay on there as well, so I will just give that a moment or two to come across. Okay, so we're about 60% of the vote there, so I'll close that down. Thank you so much, everyone, for contributing there. And I'll just pop back onto the slides, just our last two slides there. Okay, the last thing I want to just talk about is our upcoming webinars. So we will be back next month with HR Advisor Plus again on the 6th of February. And we're going to be looking at parental leave unpacked. Now that is going to form part of our statutory payments badge, which is coming next Tuesday. We're starting it next Tuesday and running it over 3 weeks. So you don't have to be part of the badge to join that session. You can join just that session alone. But if you do register and attend 4 out of the 6 sessions plus the quiz, then you will be eligible for a digital badge. So please do use the links to get yourself registered. I have popped it in the chat as well. So please do get yourself registered for those sessions. Okay, so with that, that brings us to a close on today's session. So again, I do just want to say thank you very much again to Jack and Kelly from HR Advisor Plus. It's been an absolute pleasure to have you here again today. As I've mentioned, there's lots of information in that handout, lots of links to support and also to registering for future webinars as well. So in the meantime, thank you very much from me at Sage. Take care, and we'll see you on another session really soon. Bye for now.